State's already called 10 witnesses. Um, so we've entered into the courtroom. Sean Grayson is wearing a black suit with a blue tie that has white detailing. He's chatting with the associate attorney of his defense team, Natalia Galisa. Sonya Massey and Sean Grayson's families are seated in the gallery. That's kind of weird to read. It made it seem like Sonya Massey was there. Wyckoff and Millhiser are engaged in conversation. Sean Grayson is listening intently and nodding as Foltz explains something. Judge Cadigan has entered the courtroom. The jury has entered the courtroom. The 11th witness is Seth Stoughton, a professor at the University of South Carolina School of Law. Malachi and Summer Massey, Sonya Massey's children, are seated in the gallery. Stoughton is the faculty director of the Excellence in Policing and Public Safety, EPPS program at the University of South Carolina, and a law professor teaching criminal law, criminal procedure, and police law and policy. Stoughton wrote a book titled Evaluating Police Uses of Force. The book aims to answer how society evaluates use of force incidents by examining four perspectives: constitutional law, state law, administrative regulation, and community expectations. Stoughton has testified as an expert about 150 times and at trial 16 to 20 times. Millhiser asked Judge Cadigan to accept Stoughton as an expert in the area of generally accepted police practices and use of force. Wyckoff has follow-up questions for Stoughton. So this is outside the presence of the jury, you guys. Wyckoff seeks clarification that Stoughton has testified as an expert at a criminal trial in the past. Stoughton clarifies that he indeed has. Wyckoff accepts Stoughton as an expert. Millhiser is now examining Stoughton. Stoughton, quote, "Policing is a highly diffused profession. Policing is so highly localized." End quote. He looks at what officers are doing, not to identify best practices, but to determine what a reasonably well-trained officer would think in a situation based on what officers actually do. When reviewing a case, Stoughton aims to understand all the facts and conduct and conducts a comprehensive review of all materials. Stoughton began discussing policing tactics when Foltz called a sidebar. The jury's left the room. The defense wants to make an objection based on the belief that Stoughton's testimony could lead to significant confusion with the jury because Stoughton and Grayson have different understandings of, quote, best practices. Millhiser emphasizes that they are discussing, quote, generally accepted police practices. Judge Cadigan understands from the pretrial motions that the attorneys didn't want witnesses to offer legal conclusions to the jury, so they can't say that something was justified. Judge Cadigan asks if Grayson's actions were consistent with police practices and tactics. Generally, is this what police work looks like? The expert will say no based on generally accepted practices. Cadigan wonders why that question and answer would not be allowed. Foltz says, quote, "Your Honor, again, I am concerned about your confusion." Oh, I don't know, that seems kind of spicy to say to a judge. Your Honor, again, I'm concerned about your confusion. That's bold. I think that's bold. I'm here for it. Always here for the sass. The defense believes Stoughton would discuss Grayson's actions related to Sangamon County policy and, by extension, national standards. Foltz argues that Stoughton's testimony had nothing to do with policy. Foltz explains that Grayson was trained according to Sangamon County policy, not national standards. The defense believes that not having this distinction would confuse the jury, as they would hold Grayson to a standard that he wasn't trained to. Millhiser says, "It's hard to believe we are doing this now when the defense counsel made an untimely motion." Millhiser shakes Stoughton's 40-page report in the air. Rah! The way they write this, like, it really helps. It's giving us the visuals. Grayson looks restless and stands with his hands behind his back. Judge Cadigan overrules the objection. Wyckoff talks about an expansion of the guardrails, referring to yesterday's questioning of Dekmar, and wants to be given the latitude to cross-examine the witness within the barometer of what the state is now seeking from the court. Judge Cadigan wants a break. Sean Grayson stretching against the wall during the break. He's chatting with Gallica. Yeah, we'll go with Gallica. And reaching down to touch his toes. Sonya Massey's family chats amongst themselves in the gallery while Sean Grayson's family sits staring forward. Judge Cadigan and the jury have re-entered the courtroom. Millhiser continues questioning Stoughton on police tactics. Stoughton explains that this distinction between risk and threat. It can be professionally appropriate for officers to use force when there's a threat. It is not appropriate to use force when there is a risk. A threat is defined in 3 parts. 1, ability. A subject has the physical capacity to cause harm, parentheses, if they have a weapon. 2, opportunity. Has the opportunity to cause harm, parentheses, close to the officer. 3, intention based on actions, parentheses, do they look like they're trying to cause harm? A risk is any one or two of the components of a threat. Stoughton says Sean Grayson made decisions that were tactically unsound. The decisions include pulling his gun and stepping in front of Deputy Farley. Stoughton says that at the moment Grayson draws his firearm, Massey has the ability, holding a hot pot of water, but no opportunity. She's too far away to harm Grayson. Her behavior suggests no intent to harm. Therefore, the situation poses risk, but no threat. However, Stoughton says when Grayson approached Massey after she apologized, since Grayson closed the gap, and with Massey's motion of throwing the pot, there was an imminent threat. The moment is referred to as the final frame. The final frame approach misses everything that happened beforehand that led up to the moment. Stoughton emphasizes the importance of looking at the totality of the circumstances. Stoughton synchronized both body cam footage from Department Farley and Grayson via the audio. Stoughton says, what you see in one video is only the perspective of that camera. Synchronized video allows for multiple camera perspectives. Millhiser approaches the witness with a CD. Stoughton made a full-length version, most of Grayson's cameras off, the majority of the video is Deputy Farley's camera, and took a snippet from that video when Grayson shot Massey. We are now watching both videos on the monitor. Sean Grayson is watching the full-length version intently. He occasionally leans forward to take notes. We have paused the video at the point where Sonya Massey answers the door. Stoughton says Massey showed signs of cognitive or mental health issues. We've stopped at the moment Grayson walks into Massey's house. He says this is still a casual interaction. Massey continues to show signs of cognitive or mental health issues. Stoughton says Deputy Farley did a good job of creating distance between himself and Massey as she went into the kitchen to grab the pot off the stove. Massey had the ability to cause harm, and Farley took away that opportunity by moving away. He says Massey showed no intent to harm. Stoughton says Grayson moving forward towards Massey after drawing his firearm increased the opportunity for Massey to cause harm. Sean Grayson leans his elbows on the defense table and props his head up on his hands, watching the footage. In the video, once Farley goes over to Massey's body lying on the floor after being shot, Grayson stops watching. We are now viewing the snippet of the full video that shows Grayson shooting Sonya Massey. Millhiser asked Stoughton to go over the tactically unsound actions displayed by Grayson in the snippet. Stoughton is examining the video frame by frame. The entire courtroom is silent, focused on Stoughton's frame-by-frame analysis. Stoughton says both officers could have walked out of Massey's house when she grabbed the pot, since there was no tactical need to be inside the home. Millhiser asked if the shooting of Sonya Massey was acceptable, proper, or appropriate in regards to tactics. So this is how they're doing, they can't just ask for a legal conclusion, but they're asking in terms of the tactics, your academic approach. Do you think that this was proper? So Stoughton says no. Millhiser wraps up the examination. The defense calls a sidebar regarding having enough time to cross-examine. Judge Cadigan has called a lunch break until 1 p.m. Wyckoff will cross-examine Stoughton after the break, and then they come back. So Judge Cadigan enters, Grayson's being unhandcuffed, and the jury enters. Wyckoff begins cross-examining Stoughton. Stoughton shares more details about his experience as an officer. Wyckoff puts a hand on Sean Grayson's back. Stoughton and Sean Grayson were officers for a similar number of years. Wyckoff compares Stoughton and Grayson's similar experiences, calling them similarly situated. Stoughton, the source of my expertise is as a police researcher for the past 13 years. Wyckoff references Stoughton's 40-page report. At the end of the report, Stoughton was critical of a different expert's reliance on training or work from the Force Science Institute. They have Force Science Institute? That sounds crazy. The Force Science Institute, founded by William Lewinsky. The Force Science Institute, authored 24 articles. Most of the articles were published in a journal for which Lewinsky serves on the editorial board. Stoughton describes the journal as a non-scientific journal. Wyckoff asked Stoughton if he has a good handle on what are generally accepted practices as they relate to deadly force applications. Stoughton says yes. Wyckoff reads the Sangamon County Deadly Force Application Policy. When reasonable, the deputy shall, prior to the use of deadly force, make efforts to identify him as a police officer, and to warn that deadly force may be used. Wyckoff mentioned the margin of error in the Sangamon County deadly force application, where a deputy may use deadly force to protect him or others from what he reasonably believes to be an imminent threat of death or great bodily injury. Wyckoff uses the example of taking a pen out of his pocket, and an officer shoots him because the officer believed the pen to be a switchblade. The margin of error allows for the officer to be mistaken. Stoughton says the question is whether the mistake was reasonable. Stoughton emphasizes that perfection isn't expected, but that an officer acting professionally and appropriately, a practice that falls on a spectrum, is. Wyckoff asks if Stoughton could surmise that Grayson received use of force training. Stoughton cannot confirm whether he did, as he has never seen Grayson's training materials. Thus, Stoughton can't confirm whether the training Sean Grayson received is in accordance with generally accepted practices. I do think in the report, I think I could probably pull that up really quick. And I don't know if that's gotten in front of like the jury or anything. Let me go to my drive real quick. If I don't have it, in short, I mean, Grayson wrote that he did what he did to follow his training, in accord with his training. I don't know where I put it. It might be in the description for the video we did yesterday, the stream from yesterday. But in short, I mean, my point was that he said that, he was in fear and he followed policy. He followed how he was trained. It was like a short little blurb. So Stoughton can't confirm whether the training Sean Grayson received is in accordance with generally accepted practices. Stoughton reiterates that his role as an expert today is looking at generally accepted practices. As an academic, Stoughton identifies best practices and seeks to make them generally accepted. Wyckoff further confirms that there is indeed a difference between generally accepted practices and best practices. Stoughton agrees. When reviewing use of force, Stoughton says they try to adapt an officer's mindset and not use 20/20 hindsight. He focuses on the nature of the mistake, whether it was a reasonable one, and the officer's perspective on the scene. Wyckoff asked for clarification on the Sangamon County deadly force application policy, specifically that it does not use ability, opportunity, and intent to describe threat. Stoughton says the policy does reference the same concepts, but the terminology isn't the same. Wyckoff is now asking Stoughton about the final frame previously mentioned during Millheiser's initial examination. Wyckoff says Stoughton and ISP, so that's the Illinois State Police, both reviewed the footage frame by frame. Wyckoff asked Stoughton if they came to the same conclusion that Massey started to throw the pot of water. Stoughton says, yes, we saw the same things in the same pictures. So this seems like a confirmation here that everybody's agreeing that Massey started to throw the pot of water. The defense requested a break, and I'm highlighting that because this is an expert witness that the state is putting on, but this is a very forthcoming answer for the defense. The defense requested a break. Judge Cadigan called for one until 2:35. Members of Sean Grayson's family have come over to a supporter of the Massey family during the break. They're talking and laughing. Judge Cadigan and the jury have re-entered the courtroom. Wyckoff is continuing the cross-examination. When referring to Sonya Massey, saying, quote, I rebuke you in the name of Jesus, and the pot of water. Wyckoff says, in religion, water oftentimes has meaning, right? Stoughton does not claim to be an expert or well-versed in religious meaning. Stoughton's report concluded that Miss Massey could have posed an imminent threat of great bodily harm when Massey had the pot of water and crouched, and when Grayson advanced with his firearm drawn. Wyckoff takes out Stoughton's book, referencing tactical missteps. A line from the book. Time is the single most important tactical principle in policing. Wyckoff reviews Stoughton's report and asks him to share the sources he used to inform his conclusions about Grayson's tactically unsound decisions. Stoughton cites his book, Evaluating Police Uses of Force, and various other academic sources. Wyckoff compares Stoughton to Lewinsky. Lewinsky referenced himself numerous times within his articles. Stoughton referenced his book in his 40-page report. Wyckoff asked Stoughton if he is a self-licking ice cream cone. What? Oh, I was not ready to read that. He called him a self-licking ice cream cone, similar to Lewinsky. So wait, did Stoughton is he getting that? Is this just Wyckoff's own phraseology? Or is he saying that that's how Stoughton views Lewinsky, and he's saying, "Wouldn't you be the same?" Oh my gosh. Self-driving cars, self-licking ice cream guys, what is next? That caught me so off guard. Wyckoff says, "Is this standing as witness a stop on your book tour to advance best practices?" Stoughton, "I never had a book tour. That would be nice. The book is not about best practices. The book is about generally accepted practices." The defense has no further questions. And now we're reading this. I can see why this might land in a trial that 7,000 people are watching every day, but this is a difficult to access case. That's why we would not have this access if ABC 20 wasn't giving these detailed reports. We wouldn't know about this self-licking ice cream cone thing if they weren't being detailed in their play-by-play reporting of what's going on in the courtroom. So I'm not sure this is the best question to act like this is for publicity because it's really not getting out there. But again, defense attorneys, you do want to ask the questions that go to the credibility or motives or potential liens and bias of the witnesses that you're cross-examining. So fair enough. But the ice cream cone, you guys. Yeah. So I think KP said this before we read the ice cream cone line, but I agreed and then wanted to pull it up. I was going to wait for a break. I caught it in the corner of my eye, but I like really wish it was televised so I could hear how this was said. Like, was there like a pause after? Like, did you what? Oh man. Oh man. Yeah. Yeah. Oh, so Millhiser has some redirect. So we're back to the state asking questions. Millhiser asked Stoughton if, when looking at the final frame, considering the totality of the circumstances is essential. Stoughton says yes. Millhiser referenced the defense's questions about how Grayson and Stoughton were both officers for similar amounts of time. The defense mentioned Grayson was involved in an officer-involved shooting and how Stoughton never was. Millhiser asked about the different experiences and outcomes that would arise for an officer who follows his training versus one who doesn't. Millhiser's done with the redirect. The defense has nothing to add. And then the court adjourns for the day. So that was, to put that in perspective, I mean, I felt like we did read for a little bit, but that's obviously not as long as a court day would take. And they adjourned 49 minutes ago, so like 4:45 court time. And they started at 9:41 a.m. So they had a full court day. But yeah. So there we go. That guy was on the stand all day. All day. Here is the thread. If you want to revisit that again, super appreciation here, and I should retweet the whole thread. I've been locked in on this stream. If anyone was here when we started this stream or looked at it when it was scheduled, I didn't even put a stream description. I was so disoriented trying to get together this upload of the Alicia Andrews trial with some of the names and addresses removed so we could watch it without blatantly exposing people. I really don't want to be part of the issue with like Law and Crime, Court TV, losing their access to these trials that we want to watch. So definitely trying to do my part. But yeah, didn't even put anything in the description, but gotta show some love to ABC 20 here for, not just covering the case for the sake of an article, but giving the play-by-play when there's no cameras in this courtroom. This could be the way we'd have to consume the Alicia Andrews trial. And I don't love that. I don't like that prospect. So let's see. Yeah, who knows about the self-licking ice cream thing? I had the stream open in one of these tabs for okay. Day three. We are going to bump this up on speed a little bit, you guys. I need to get a drink. Not a happy hour drink quite yet. I gotta get like an ice water. All that reading. So we'll get this started. We'll make sure there's something for you guys to watch. I'm gonna step away